These rules become even more important. Without them, we risk becoming an island of strangers.
Hello everyone. This is an important update on significant changes to the UK's immigration rules that affect nearly everyone applying for a visa, an extension, indefinite leave to remain ILR or citizenship. The Home Office has consolidated and strengthened its suitability requirements, giving it broader powers to refuse applications and cancel existing permissions. These rules are effective now and have replaced the old Part 9 of the immigration rules. Let's get straight into what these grounds for refusal or cancellation are. They are divided into mandatory grounds, where a refusal is required, and discretionary grounds, where a refusal is possible. Before we continue, please subscribe to the channel and turn on notifications for upcoming updates. Now, let's delve in. These are the most serious grounds. If any of these apply to you, the Home Office must refuse your application. Exclusion or deportation orders indicate that if you are subject to a deportation order, an exclusion order from the Secretary of State, or a travel ban, your application will be automatically refused. Criminality plays a significant role. Your application must be refused if you have been convicted of a criminal offence in the United Kingdom or overseas that resulted in a specific length of imprisonment. A sentence of 4 years or more leads to a mandatory refusal, regardless of when it happened. Sentences between 1 and 4 years also lead to refusal unless a significant period has passed. Deception is critical. Your application must be refused if the Home Office is satisfied that you have used deception. This includes providing false information, submitting fraudulent documents, or failing to disclose relevant facts in your application. Importantly, this applies to your current application and any previous applications you have made. Even if the deception is discovered after your visa has been granted, your permission can be cancelled. A sham marriage or civil partnership will also lead to refusal. If the Home Office has reasonable grounds to believe you are or have been involved in a sham marriage or civil partnership to gain an immigration advantage, your application must be refused. Previous breaches of immigration law are also grounds for refusal. If you have previously breached UK immigration laws, including overstaying your visa, entering the UK illegally, or breaching the conditions of your leave, your application must be refused. There are very limited exceptions. For example, if you applied for a new visa within 14 days of your previous one expiring, but relying on this is risky. For discretionary grounds for refusal, a Home Office decision maker may refuse your application, considering the specific circumstances of your case. Non-conducive to the public good is a very broad category. Your application can be refused if your presence in the UK is deemed not conducive to the public good due to your character, conduct, or associations. This can include criminal convictions that do not meet the mandatory refusal threshold or other behaviour that the Home Office considers undesirable. Failure to provide information can also lead to refusal. Your application may be refused if you fail to comply with reasonable requests from the Home Office. This includes failing to provide required information or documents, not attending a requested interview, refusing to provide biometrics, or not undergoing a required medical examination. If you have an outstanding debt to the National Health Service valued at least £500, your application for entry clearance or permission to stay may be refused. It is crucial to pay any NHS charges you incur. Unpaid litigation costs are another reason for refusal. If you have been ordered by a court to pay litigation costs to the Home Office and have failed to do so, your application may be refused. Medical grounds may lead to refusal if a medical inspector has advised the Home Office that it is undesirable to grant you entry for medical reasons. You may also be refused if you fail to produce a recognised passport or travel document. Rough sleeping in the UK is a specific and nuanced ground. Permission to stay may be refused if a person has been sleeping rough and has also repeatedly refused offers of suitable support while engaging in persistent antisocial behaviour. This is not simply about being homeless. Even if you have a valid visa, it can be cancelled under these new suitability rules. Many of the grounds for refusal also serve as grounds for cancellation. Withdrawal of sponsorship or endorsement is significant if you are in the UK on a sponsored route, such as a skilled worker visa, and your employer withdraws their sponsorship, your permission can be cancelled. The same applies if an endorsing body for routes like the Global Talent Visa withdraws its endorsement. For failure to commence or ceasing study or work, if you are on a student visa and you do not enroll in your course, or if you stop attending your studies, your university is required to report this to the Home Office, which can lead to your visa being cancelled. Similarly, if you have a work visa but do not start your job, or you cease your employment, your visa can be cancelled. Unauthorized absences from your employment can also be a reason for cancellation. Change of circumstances can also impact your visa if your circumstances change in a way that means you no longer meet the requirements of your visa. Your permission may be cancelled. For instance, a worker changing to a job with a salary below the required threshold for their visa may have their permission cancelled. Dependents are also affected. A dependent's visa is linked to the main applicant. If the main applicant's permission is refused or cancelled, the permission for their dependents may also be cancelled. There is a specific rule clarification that offers a new opportunity for students. A student can now engage in self-employment under very specific conditions. This is permitted only if the student has applied for permission under the Innovator Founder route, and that application is supported by an endorsement from a recognised Innovator Founder endorsing body. The application must have been made while the applicant still had valid permission as a student, and the decision must not yet have been made on that Innovator Founder application. This allows entrepreneurial students to begin working on their endorsed business idea while their application is being processed, which was not previously allowed. In conclusion, the new suitability rules emphasize the importance of an applicant's entire history and conduct. Honesty is crucial, as any deception can result in mandatory refusal. Compliance with visa conditions is essential, covering work, study, and public funds. A clean record is necessary, as issues like criminality or unpaid NHS debts can severely impact immigration outcomes. Attention to detail is vital. Applications must be timely and complete, with prompt responses to Home Office requests. These complex rules grant significant power to decision makers, making it crucial for applicants to be aware of their obligations and maintain order in their immigration matters. Staying informed and diligent is essential.
So when you have an immigration system that seems almost designed to permit abuse, that encourages some businesses to bring in lower paid workers rather than invest in our young people, or simply one that is sold by politicians to the British people on an entirely false premise, then you're not championing growth, you're not championing justice, or however else people defend the status quo. You're actually contributing to the forces that are slowly pulling our country apart. And because it is what I believe in, nations depend on rules, fair rules,